I don't understand why people do that. You met some guy that you barely knew, and next thing you know, a complete stranger is living in your house. And in my day, you are the person that they used to do after school specials for. You're just a walking Lifetime movie waiting to be happening. And you know what? Mom and I will sit and watch that Lifetime movie. And you know what we'd say? Oh, no, there's no way somebody would let a complete stranger who has no job move in with them. This can't be a true story. And then you know what happens in the Lifetime movie? The screen goes black, and then you got a law named after you.
The judge leaned forward. "I don't understand why people do that," she said, and the courtroom went still. "You met some guy that you barely knew, and next thing you know, a complete stranger is living in your house." She wasn't finished. She compared the defendant's life to a television movie, the kind where the screen goes black and a law ends up named after the victim. The defendant, sentenced to state jail minutes later, wasn't a stranger to this courtroom. She was days from graduating a program built to keep her out of it. By the end of this video, you'll understand how a probation violation hearing works and why a judge's words can hit harder than the actual sentence. On a date established in the record, Bianca Argolo appeared before Judge Stephanie Boyd in a Texas courtroom on a motion to adjudicate guilt. Argolo had been placed on deferred adjudication in 2019, case number CR 10418, for possession of a controlled substance, penalty group 1, less than 1 gram, with a 4-year probation term beginning February 24, 2021. The state represented in court alleged she'd violated condition number 2 of that probation.
Are you saying Bianca Argolo, who was placed on deferred adjudication in 2019, CR 10408, for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on February 24, 2021, for a term of 4 years? Is that you? All right. And do you plead true to violation of condition number 2 in that motion as well? And state, are you waiving all of the allegations?
Yeah, Your Honor.
Argolo, appearing without a jury and pleading true to the violation, faced up to 2 years in a state jail facility and a fine of up to $10,000.
Did you understand in each cause number, by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2 and each cause number?
Before this hearing, Argolo was not a stranger to the system, but she was close to leaving it behind. She held a job, one she'd managed to keep even through supervision, and was renting her own house. She had 2 children, though they currently lived with their father. She was enrolled in felony drug court, a specialized program combining treatment and judicial oversight that offers people facing addiction-related charges a path to avoid incarceration if they complete its requirements. She had already finished 2 of its component programs, SFPF and DDRF, residential and outpatient treatment components respectively. She was, by her own account and the record before the court, weeks away from graduating.
All right. And what has she done on probation?
Your Honor, she was in drug court and she was doing fairly well in drug court. She was a couple of weeks from actually graduating and she relapsed. She completed the dual diagnosis residential facility and she completed safe P.
You want to raise your...
The specific cost of that near miss was steep. Instead of walking free from 4 years of supervision, she was now facing state jail time and the collapse of every month she'd already put in. The state's position was that Argolo had violated a clear, explicit condition of her supervision. No contact with a specific individual a man drug court had identified as a risk to her recovery. The record established that this wasn't a first offense within the program. Argolo herself acknowledged during the hearing that she'd been given multiple chances before this violation triggered termination. The man in question had moved into her home during a 4-day jail sanction she was serving for a separate infraction, and when she made contact with him afterward, the program terminated her.
Well, what do you mean you did contact him? He's living with you.
Yeah, he was living.
Why is he living with you?
He wasn't at the time, he just didn't have anywhere to stay. He was there for about a week, and then my dad ended up going over that weekend when he found out that I was doing the 4-day jail sanction and kicked everybody out of it.
The state's proposed agreement recommended 1 year in state jail, with credit for time served, running concurrently across her cases, and credit for successfully completed program components.
There is, Your Honor. We're asking that you adjudicate the defendant guilty, revoke her community supervision, and sentence her to 1 year in the state jail.
All right. And is that what you're requesting?
It is, Judge, and that the time be run concurrent, and she should have credit for time served in both cases. She has 480 in one case and 478, I believe, in the other, but she also did 9 months in safety.
Most people watching this hearing miss what actually happened just beneath the surface of the state's request. The prosecution's own proposed sentence was already softer than what the violation technically permitted, suggesting even the state recognized mitigating weight in her nearly completed program history. This is where felony drug court operates differently than standard probation. Programs like this one exist under specialized court statutes, often modeled on drug court frameworks authorized at the state level that trade strict enforcement for treatment, focused supervision, with violations typically met by graduated sanctions rather than immediate termination. In plain terms, most drug courts give repeated warnings and structured consequences before pulling someone out entirely, precisely because relapse and boundary violations are treated as part of the recovery process, not proof that treatment failed. The open question hanging over this hearing was whether Argelo's specific violation, maintaining contact with a person she'd been explicitly warned about, crossed a line those graduated protections were never meant to cover. What followed wasn't a cross-examination in the traditional adversarial sense. It was the judge questioning Argelo directly, under oath, about what actually happened. Judge Boyd pressed her on why she hadn't successfully completed probation, and Argelo initially offered a vague answer. She'd gone around the wrong people again. The judge pushed further. What does wrong crowd mean? Argelo admitted she'd reconnected with people she'd previously distanced herself from. Then came the detail that reframed everything. During a 4-day jail sanction for a failed drug test, the man in question moved into her house. When her father discovered this and removed everyone from the property, Argelo still made contact with the man afterward, and that contact, not the relapse itself, is what ended her time in the program. Here is the sentence that will get quoted from this hearing. That's when they decided to terminate me. In real-world terms, that timeline matters enormously. It means the program had already tolerated her relapse and given her another chance, and the violation that actually ended her participation was a communication choice made after a warning, not a failure of willpower during treatment.
Okay, so I didn't tell them. I did try to lie about it in the beginning, but when I went in to talk to the judge, I already knew what it was about. I didn't know what it was about.
Because you know they found out.
They didn't find out he was living with me, but I let them know that day because I just knew that he pulled up the records. I know how Judge Flynn is, and I know they've given me multiple chances, and so they had to tell me that was it. And I understand that I was in there for 3 years, so I know Elsa knew me very well.
What should have happened differently starts with how program termination decisions get made. Under standard graduated sanction models used in many felony drug courts, a first instance of prohibited contact typically triggers escalating consequences. Increased check-ins assign counsel to assist in formally removing a prohibited person from a residence, rather than outright termination, and Judge Boyd herself referenced this exact protocol from her own experience as a former drug court attorney. If that graduated process had been followed here, Argelo's near completion of the program might have been preserved rather than erased in a single violation. The human cost of that gap is not abstract, It is the difference between walking free after 4 years of supervision and reporting to a state jail facility for up to 18 months, with 2 children who now wait even longer for their mother's full return to their lives.
You have children,
They have 2 children there with their dad.
and you letting this man come in your house, just put your children before that man. Were you planning on ever having visitation with your children? And then you know what would have happened? You would have had visitation with your children, and that man would have been there, a complete stranger. And children are always depending on their parents to alert them to danger and not bring danger to him. And you know how children sometimes end up getting abused and murdered because parents are letting complete strangers come live with them. And that same guy that you have who's not working, and then he sends you off to work and you leave your children with a complete stranger. That's what happens. All of this because people have, I guess, no self-esteem for themselves or lowering their standards.
There is no formal appeal mechanism for a defendant to challenge whether a program actually followed its own graduated sanction protocol before terminating her. That determination rested entirely within the drug court's internal discretion.
I don't know why I should just give her a year for disobeying the rules of felony drug court. And I don't think it's just one time. Felony drug court doesn't do this thing because I used to be an attorney in felony drug court. If I were in felony drug court, they would say, Stephanie, we don't want you having contact with John Doe because John Doe is a drug user. John Doe sells drugs. Don't have contact with him. And I'm like, oh, okay. And then they catch me with John Doe. You know what they do? They don't kick me out of drug court. You know what they say? Hey, this is the last time we're going to tell you. We're giving you this amount of time to get John Doe out of your apartment. And if you have issues with John Doe getting out of your apartment that's in your name, here's an attorney for you. They will do the necessary things and tell you what you need to do to have that person removed from your apartment. I know they did that. And I don't think you told them John Doe was living with you. I think you were shocked. They learned he was living with you.
The legal element at the center of this hearing was whether Argelo's plea of true to the violation was made knowingly, and whether the court's own broad discretion in adjudicating deferred probation violations under Texas Code of Criminal Procedure Article 428.751 permitted the judge to depart from the state's own recommendation. That statute gives judges wide latitude once a violation is admitted. The court isn't bound to follow either side's suggested sentence. Most people assume a judge simply signs off on whatever the prosecution and defense negotiate. That isn't how deferred adjudication revocation works. Once a violation is pled true, the original range of punishment reopens entirely, and the judge alone decides where within that range the sentence lands, regardless of what either side requested going in. The state's closing position, effectively made through its proposed 1-year recommendation, argued that Argelo's pattern of repeated boundary violations within a program built on trust and accountability justified real incarceration, tempered by credit for the substantial progress she'd already made. The defense's position, implicit in accepting that same negotiated recommendation, was that her demonstrated program completions and stable employment showed genuine rehabilitation, interrupted by a single serious lapse in judgment, not a wholesale failure to change. The open question neither side's proposal fully resolved was this: does a judge, hearing the full emotional weight of a defendant's choices, owe more weight to the progress already made, or to the specific trust that was broken in making it? Judge Boyd's ruling arrived after an extended, pointed rebuke addressing far more than the legal violation itself. She found the violation true in each case. She sentenced Argelo to 18 months in state jail, 6 months longer than the state's own recommendation, while crediting her for time already served and for successfully completing both SFPF and DDRF.
Include her safety.
Did she successfully complete it?
It's my understanding.
Probation, did she successfully complete safety?
Yes, sir. And I believe DDRF. Yes, sir.
Okay. I'll give you credit for safety because you successfully completed. And I'll give you credit for DDRF. Did she successfully complete DDRF?
This ruling reflects the broad discretion Texas law grants judges once a probation violation is admitted. Article 42A.751 exists precisely so that sentencing authority returns fully to the court, insulated from being bound by either party's negotiated position. This is the same discretionary sentencing principle that underlies revocation hearings nationwide, distinct from a criminal trial. Once a violation is established, the judge's assessment of the full record, not just the party's agreement, determines the outcome. This case is not really about a probation violation. It is about how much weight a single relationship choice can carry when someone is already standing on the edge of freedom. Every American navigating supervised release, drug court, or any conditional second chance is one decision away from having months or years of progress reset by a single lapse. Argelo's near graduation didn't erase the violation. It simply meant the cost of that violation landed on someone who had almost made it all the way through. Next time, we're examining a case where a first-degree felony was resolved entirely through a stipulated plea, with no live witness ever taking the stand, and what that reveals about how often trial by evidence alone decides serious cases in America. Was Bianca Argelo's 18-month sentence a fair response to a genuine pattern of broken trust within a treatment program built on accountability, or is it evidence that judges sometimes let personal moral judgment about a defendant's relationship choices outweigh the legal standard the violation was actually supposed to be measured against? And if it's the latter, what real check exists on that kind of discretion?